All right, everybody ready? Good morning. Thank you. That's better. The time is now 9:33 a.m. Today's date is Tuesday, January 10th, 2023. This is the time and place for our regularly scheduled scheduling meeting. We are in the Bollinger Conference Room of the Montana PSC. I call this meeting to order. Would my colleagues join me in reciting the Pledge of Allegiance? Flag of the United States. Republic for which one nation. All right. Thank you, colleagues. I would note for the record that all 5 commissioners are present in the Bollinger Room this morning, so we do have quorum. This is the time and place for public comment. The Montana Public Service welcomes any interested member of the public to provide public comment on any matter, the agenda, or any matter generally. Are there any commenters in the room? Seeing none. Are there any commenters online? None. No public comment this morning. We have no changes to the agenda this morning. So let's move right into action item number 1. That's approval of the commission minutes for the week of January 3rd, 2023. Is there a motion? I'll move to approve the minutes for the week of January 3rd, 2023. Is there a second?
Second.
Seconded by Commissioner O'Donnell. Discussion. Are there any changes to the minutes? Any revisions? Seeing none, all those in favor of my motion to adopt the commission minutes for the week of January 3rd, 2023 signify by saying aye.
Aye.
All those opposed signify by saying no. Seeing no opposition, motion carries unanimously. Minutes are approved. Let's move right into our work session. Work session item number 1 is rule review appointment. This is a commission initiated matter. We're here to consider appointing Laura Vikowski as the agency's rule reviewer, with Dan Polko as the agency's backup rule reviewer. Mr. Hamilton.
Thank you, Mr. President and commissioners. This is a very simple, I think, work session to start off with. Montana code requires the commission to designate a rule reviewer who signs every rule-making notice that the commission issues. The obligations of that rule reviewer are spelled out in Title 2, Chapter 4, Section 110. Basically, they have to check the rule to make sure that it satisfies all the basic requirements of rulemaking. At present, I am your designated rule reviewer. However, I am now also your chief legal counsel, and in order to ensure that there is always someone available to look at the rules as part of the rule reviewer process, I do recommend that the commission appoint Laura, our staff attorney, as your new primary rule reviewer, and Dan Polkow, our second staff attorney, as a backup rule reviewer. Between the two of them, I believe that we'll be able to promptly respond to all the Secretary of State's requests for edits and modifications of any rulemaking notices that go out, and provide prompt responses to the commissioner's requests for rulemaking. With that, again, staff's recommendation is to appoint Laura Vikowski as your primary rule reviewer and Dan Polkow as your backup rule reviewer.
Thank you, Mr. Hamilton.
Motion to approve.
Thank you, Commissioner Bukacek. We have a motion to approve. Is there a second?
Second.
Vice President Fielder has seconded. So we have motion second. Discussion, questions? Seeing none, all those in favor of Commissioner Bukacek's motion to approve Laura as the agency's reviewer with Dan as the backup, it signify by saying aye.
Aye. Aye.
All those opposed signify by saying no. Seeing no opposition, motion carries unanimously. Thank you, Mr. Hamilton. Definitely handled. All right. Our second work session item number 2 is related to the 2023 legislature. This is a commission initiated matter. We're here to discuss Montana legislature bills relevant to the PSC's mission, statutory authority, administrative process, and general agency concerns, which may involve discussions related to the PSC budget request presentation. We're going to hear staff analysis and recommendations, and that may provide direction to the PSC as to how we want to respond to bills. Morning, Mr. Rosequist.
Good morning, Mr. President and Commissioners. So today, I would like to just give the Commission an update on the status of the 4 bills that the PSC requested through the Energy and Telecommunications Interim Committee to be pre-introduced. And then I'll summarize a few other introduced bills that the staff is tracking that the Commission might be interested in. So starting off with House Bill 52, revising common carrier regulations. The Commission requested introduction of this bill to clean up obsolete portions of the statute, specifically Chapter 11, which provides requirements for common carriers. The Commission feels that these provisions are outdated, preempted, have been replaced by other statutory chapters, including Chapter 12 for motor carriers, Chapter 13 for pipelines, and Chapter 14 for railroads, or the provisions are otherwise addressed through common law. The bill was heard yesterday in front of the House Energy, Telecommunications and Federal Relations Committee. President Brown supported the bill on behalf of the Commission. There were no opponents to the bill and no action was taken on that bill. Senate Bill 32, revising pipeline safety regulations. This is a bill sponsored by Senator Mike Cuff that revises Montana Code annotated 69.3207 to revise the penalties provided for in that portion of code so that they align with federal regulations for what appropriate penalties can be, the maximum amount of those penalties. The Commission requested this bill because of an audit that we had on our pipeline safety program, which noted that the state's penalties were misaligned with respect to federal regulations, and unless those penalties are brought into alignment, the grant that the Commission gets from PHMSA could be reduced.
Mr. President, question on that. To whom do those penalties go? If the state has to conform to the federal, if there's a violation, to whom does the money go?
Mr. President, Commissioner O'Donnell, whenever the Commission issues a fine, the amount levied goes into the general fund. The Commission doesn't get those funds.
So even though it's a federal regulation, that the money stays with the state general fund, is that correct?
Correct, Mr. President. Commissioner O'Donnell, it's the Commission who's levying the fine under its authority to implement the state program. So the fine goes into the general fund.
Thank you.
So this bill was heard in front of the Senate Natural Resources Committee on Friday, January 6th. President Brown again supported the bill on behalf of the Commission. There were no opponents to the bill and no action was taken by the committee at that time. Senate Bill 33 repeals Class C motor carrier regulations. This bill is also sponsored by Senator Mike Cuff. This bill repeals statutory provisions in Title 69, Chapter 12 regarding the regulation of Class C motor carriers. The Class C motor carrier is a carrier that provides transportation service under a contract, charter, or agreement that establishes the price or charge for the service. Historically, Class C carriers were the original transporters of passengers and goods. Class C transportation service typically involved offloading merchandise from railroads, transporting it to stores, manufacturers, farms, etc., within a specific town. And Class C also involved transportation of railroad crews and equipment. The Commission is seeking repeal of Class C because we feel it's obsolete. Transportation of freight has been federally preempted, and the legislature in the 2021 session repealed the household goods and passengers through repeal of Class B regulation. Senate Bill 33 has been referred to the Senate Highways and Transportation Committee, and a hearing is scheduled for Thursday, January 12th in room 405 at 3 o'clock. I believe President Brown and myself will be appearing at that hearing to convey the commission's support for that bill. The fourth bill that the commission sought pre-introduction for has not officially been introduced yet. It is LC 369. It revises telecommunications regulation by repealing a number of provisions of the Montana Telecommunications Act, which is Title 69, Chapter 3, Part 8. We're proposing to repeal a number of these provisions because of the ongoing development of competition in the telecommunications area. Part of the provisions being repealed also address a state universal service fund, which has never been used since it was enacted. And under that state universal service fund authority, the commission does not have authority to establish a fund that would support broadband service, which is one of the potential problems. And it also doesn't allow the commission to require all telecommunications providers to contribute to this universal service fund, which may be another potential implementing problem. And finally, one of the things that LC 369 does is to repeal the performance assurance plan, which is an obsolete portion of the statute, because commission terminated Quest's performance assurance plan in 2020, and no other carriers are able to implement that plan. I believe that the status of that is that Senator Daniel Zolnikoff will be the sponsor of that bill, and a draft of the bill has been sent to him for his review at this point. Moving on, Mr. President, to several bills that the staff is tracking that the commission may be interested in. The first is House Bill 170, which would repeal the state's energy policy. House Bill 170 is sponsored by Representative Steve Gunderson, and it would just repeal the entire state energy policy established in Title 90, Chapter 4.
Mr. Question.
Commissioner
So
O'Donnell?
does the bill just abolish that and ask for an update or a revision of it, or?
Mr. President, Commissioner O'Donnell, it is a very straightforward bill of a couple of sentences that just repeals the entire energy policy.
Interesting. Thank you.
Doesn't replace it with anything that I can. House Bill 176, revising county utility permitting laws. This bill is sponsored by Representative Stephen Galloway. It revises county utility permitting laws in Title 7. The revisions expand the scope of infrastructure a board of county commissioners is authorized to grant a person, association, or corporation the right to construct by including broadband infrastructure. The revisions also expand the scope of places in which a board of county commissioners is authorized to permit construction of infrastructure by including county easements or places within or on county-owned property, within a county utility corridor, and within a county right-of-way. And then the bill makes similar changes to authority of a city council or a town council with respect to property rights of way, utility corridors, and easements of the city or town. A hearing on that bill is scheduled for tomorrow, January 11th, in front of the House Energy, Technology, and Federal Relations Committee.
Mr. President, another question. As I understand that bill, by giving the counties the right of eminent domain, basically, that was the purpose of the bill is to accelerate the building up of broadband infrastructure within counties. Is that correct?
Mr. President, Commissioner O'Donnell, I really don't have any information on the intent or purpose behind this bill.
Thank you.
Mr. Fielder?
Just a question based on Commissioner O'Donnell's question, and that is that the term eminent domain, I'm not reading that into this. They're talking about the description of the bill is limiting this to county-owned property. It looks like it doesn't look like an eminent domain type of a thing. Am I misreading that?
Mr. President, Vice President Fielder, no, I can say that the bill does not refer to eminent domain, and you're correct that it appears to be directed at property owned by or controlled by the county or the city or town.
I will add, Mr. President, that I spoke with a owner of an apartment building. It wasn't in this state. He owns buildings in another state, who was telling me about the broadband utility company coming in and digging a large trench in his property without consent or anything, just running these lines right through his property, big, deep, wide open trench through his lawn. And he was pretty frustrated about that and wasn't able to find any resolution to it. So I was surprised that a company would do that without permission, but I don't know if this will help with that type of issue or not. But it seems like if the county's providing the permitting or the city's providing the permitting, perhaps it will. I'm sorry. It's just one of those things we would probably be hearing about if that were to happen in our state, to one of our constituents' private property.
Just for clarification, my use of the term eminent and it was a poor choice of words, but meaning that the counties or municipalities can assign utility status so that they don't have to get the permission of the property owner to access that property. And for instance, in Billings, at the house that I just sold, the company TDS had that right given to them by the city of Billings, as I understand it. And they did trenching in there, but they made the promise that they would fix it, and they did an absolute perfect job on that. So it would depend upon the ordinance the county or the jurisdiction would have, whether or not the cleanup of that is required. And in this case, it was required, and it was fulfilled nicely.
So the president's going to make a point of order here. So generally under Robert's Rules of Orders, we don't discuss anything unless there's a motion that's made. I'm happy to entertain questions or have our staff entertain questions on bills to determine whether or not motion should be made, but let's limit discussion to questions. And then if there's a motion to be made, then we can discuss the merits or content of the bill. Please proceed, Mr. Rosequist.
Thank you, Mr. President. The next bill would be House Bill 191, which would eliminate Class D motor carrier regulation. House Bill 191, sponsored by Representative Brad Barker, repeals the provisions of Title 69, Chapter 12, that establish regulation over Class D motor carriers, which involves garbage hauling. The next bill is Senate Bill 97, which is called Implement Renewable Portfolio Standard Production Tax for Property Tax Relief. SB 97 is sponsored by Senator Keith Regier. It creates an account in the state special revenue fund for school transportation property tax relief. Revenue from a renewable resource electrical production tax is deposited in the account, and the superintendent of public instruction administers the account and uses the funds in the account to reduce county contributions to school district transportation funding requirements, with the savings used to reduce property taxes. The bill establishes an electrical energy producer's license tax of 0.02 cents per kilowatt hour and a renewable resource electrical production tax rate of 0.1 cents per kilowatt hour, with an exemption for certain eligible facilities of 25 megawatts or less. And finally, Mr. President, Senate Bill 109, revised laws related to redistricting the PSC. SB 109 is also sponsored by Senator Keith Regier. It revises Public Service Commission districts established in Title 69, Chapter 1. The bill adds Glacier, Muscle Shell, and Pend Oreille counties to District 1 and adds Deer Lodge County to District 4. The bill requires the legislature to evaluate existing commission districts during the legislative session following receipt of the official final decennial census data. The bill has been referred to the Senate Energy and Telecommunications Committee.
Mr. Rosequist, on this last one, it appears what this bill is doing is codifying the federal court decision as to PSC districts. Would you agree with that?
That was my assessment as well, Mr. President.
Thank you, Mr. Rosequist. Okay, Commissioner Panoche.
Thank you, Mr. President. 191 would take the commission out of garbage regulation completely. Is that correct?
Mr. President, Commissioner Panoche, that is my understanding.
So some questions I have as follow-up, Mr. President, is so I'm approached on the House, well, I guess in the halls of the Capitol. You'll support this, won't you, Commissioner Panoche? And I said, well, let's say we get out of the garbage regulation. What prevents the garbage haulers from doubling the price of garbage? What do I tell what's a good answer to give to that?
Mr. President, Commissioner Panoche, I guess the first thing I would note is that at this point, the commission does not rate regulate garbage haulers. We currently regulate the entry into the market, and we can consider the impacts of competition in making those decisions. Absent the commission role in regulating entry into the garbage hauling business, that may result in additional entities seeking to enter into various garbage markets. And the ultimate effects on that on prices are, somewhat hard to predict at this point. It would be a dynamic process to see, how existing carriers respond to the existence of other carriers, how long those other carriers last in the market, how the market ends up segregating itself if it does. Those are complicated sort of economic questions that I'm not really able to answer right now. And so unfortunately, I can't say whether the repeal would lead to an increase or a decrease over the long run in garbage prices, Mr. President.
Follow up, Mr. President.
Follow up.
So an answer I could give is Public Service Commission doesn't regulate pricing in garbage. So there shouldn't be an effect with that. But we were looking at an article the other day where a gentleman goes out and borrows a lot of money to get into the garbage business. And then he gets slapped with a lawsuit. And the article went on to say that the Public Service Commission is horrible. This guy's lost his life investment. But we don't regulate whether or not competition can file a lawsuit against a new entity. So I think that was an unfair article. But if we get out of the garbage, then they can't do articles about us like that. So that would be a positive side. We couldn't get blamed for something that we're not even responsible for. Now, the answer I'm given to the individuals calling me is you have to change that in the legislature. We can't prevent a party from doing a lawsuit. But I'm curious, if the Public Service Commission's out of this, can anyone haul garbage, and who will decide that if we don't? What do I tell the public?
Mr. President, Commissioner Panoche, if the commission is not involved in garbage regulation, there will be no barriers to any entity that wants to get into the garbage hauling business that I can see. And yes, That's about all I can say, Mr. President.
Follow up, Mr. President.
I would just remind my colleagues that we are all defendants in a lawsuit that is presently being prosecuted against the Montana Public Service Commission about our ability to regulate Class D licenses and garbage haulers, and I would encourage my colleagues to refrain from any further questioning on this matter unless they want to do a motion to have the commission take a position on House Bill 191, which in turn would be information that would be used in the lawsuit against us. Mr. Pinochi.
I guess my question is this. When the ratepayer comes to me and says, what does this mean? I'm trying to come up with some answers to answer that question. But I certainly don't want to be involved with someone saying we shouldn't have said something based on us going through a case. But I still am struggling to answer questions to people who are coming to me saying, if you get out of the garbage business, what does that mean to us as a ratepayer and garbage? And I don't know all those answers, but I'd like to get better at answering those questions when I'm asked. Mr. President, thank you.
Thank you, Commissioner Pinochi. All right, seeing no motions to either support or oppose any legislation that was discussed today, I'll move to announcements. I'd remind the public that at 1 p.m. today, Commission will be holding a rules adoption and repeal hearing on notice number 38-2-258, which involves the Commission's intervention rules and procedures. That hearing will be here in the Bollinger Room. Commissioner Pinochi will be chairing that. We were scheduled to have a hearing tomorrow at 9 a.m. on Northwest Energy's application for approval of corporate restructuring. That hearing has been canceled so that the commission can determine the merits of a proposed settlement agreement that has been filed with the commission. And then the commission will be appearing before Legislature Subcommittee D, Appropriations Subcommittee, at the Capitol Building on Friday morning. We believe that will be at 8 a.m. and Route 317. And I would just note for the public's consumption that the commission is regularly noticing up legislative work sessions so that if a bill arises that we need to take immediate action on, we will do that. The next commission business meeting will be Tuesday, January 17, 2023 at 9:30 p.m. Thank you for that correction. Seeing no further business to come before the commission, I will adjourn today's meeting. Time is now 10:01 a.m.